Sentencing a convicted person is one of the most complex parts of the legal system. A judge must weigh several factors when deciding how to sentence an offender. In Canada, a judge has numerous sentencing options, which range from releasing the accused to imprisonment. The sentencing process is controversial to many Canadians, as most convicted offenders do reintegrate back into society at some point. There is constant debate over just how hard or soft convicted offenders should be treated by the justice system. In 1995, the Criminal Code was amended to provide judges with clearer direction when sentencing convicted offenders. Each sentence issued by a judge should reflect as many of these four objectives as possible. 1. Denouncing unlawful conduct. 2. Deterrence. 3. Separation or segregation. 4. Rehabilitation. Part of any criminal sentence should involve denouncing or condemning unlawful conduct. It should be clear to the offender that what he or she did was wrong from the viewpoint of society. When convicted offenders are sentenced, their characters and past behaviors are considered. If they are repeat offenders, or if the crime they committed is severe, their behavior will be denounced in the strongest terms, and that should be reflected in the sentence they receive. A sentence is supposed to deter or prevent an offender from committing more crimes. Deterrence can be divided into two types. Specific deterrence, a sentence that discourages a particular criminal from reoffending or committing another crime in the future. General deterrence, a sentence that discourages the general public from committing a particular crime. Another purpose of criminal sentencing is to separate or segregate offenders from society. This usually involves incarcerating the offender, putting them in prison. Incarceration is not always necessary. If an offender is not considered dangerous, they may avoid a prison sentence and be reintegrated into society sooner. As of 2008, Canada's incarceration rate per every 100,000 people was much lower than that of the U.S. and one of the lowest in the world. Since most convicted offenders rejoin society at some point, the Criminal Code also states that a sentence should try in part to assist or rehabilitate offenders so they can avoid a life of crime. Recidivism is the act of recommitting crimes, being a repeat offender. Rehabilitation looks to provide offenders, particularly prison inmates, with important skills they need to be productive members of society. Examples of rehabilitative programs include job training, counseling, and opportunities for education. In addition to denouncing unlawful conduct, specific and general deterrence, segregation and rehabilitation, there can be a few other objectives in sentencing. Reparations, repaying victims and/or the community for harm done. Remorse, judges will consider whether or not the offender expresses sincere regret for his or her guilty actions. In Canada, judges usually have discretion when imposing sentences. For some cases, there are mandatory minimum sentences created by Parliament that a judge must follow. Before a judge issues a sentence, he or she reviews a pre-sentence report on the offender. This report may include aggravating and mitigating circumstances as well as victim impact statements. A judge considers aggravating circumstances. Factors that demonstrate the punishment should be more severe. The sentence should be harsher. Mitigating circumstances. Factors that demonstrate the punishment should be less severe. The sentence should be less harsh. The victim impact statement. A statement made by the victim or on their behalf that describes how the offense affected his or her life and loved ones. When many Canadians hear the term sentencing, they think of imprisonment. However, there are several other options available to a judge. Absolute or conditional discharge, suspended sentence and probation, conditional sentence, suspension of a privilege, peace bond, restitution or compensation, community service, deportation, or fines. For a crime that carries a maximum sentence of less than 14 years, an offender may receive one of two possible discharges. An absolute discharge: the offender is released without condition and with no criminal record. Conditional discharge: offender is released with conditions or terms which, if completed, results in no criminal record for the offender. Discharges are usually only granted if it is the offender's first offense and it is not a very serious crime. Although there is no criminal record, it is noted that the offender was granted a discharge. A suspended sentence is a punishment that is not carried out as long as certain conditions are met. This sentence usually involves probation. Probation is a punishment that allows an offender to live in the community, but with certain conditions and supervision, that is, reporting to a probation officer. The main difference between a suspended sentence and an absolute or conditional discharge is that with a suspended sentence there is record of criminal conviction. If the maximum sentence is less than 2 years, a judge may impose a conditional sentence. This sentence allows the offender to serve their time in the community instead of prison. A judge must be reasonably sure the offender is not a threat to the public. The offender must also keep the peace and be of good behavior. Additional orders may include curfews or abstaining from drugs and alcohol. The suspension of a privilege sentence takes a privilege away from a convicted offender for a specific or indefinite period of time. The most common suspension of a privilege is a driver's license. Another common example is suspending restaurants' liquor licenses. A driver's license is usually surrendered to the court clerk by the driver before he or she leaves the courtroom. Liquor licenses are often removed if an establishment has violated liquor laws and regulations. A peace bond comes in the form of a court order requiring a person to keep the peace for up to 12 months. A peace bond is a common sentence in harassment or assault cases that are not very serious. A common criterion for a peace bond includes staying away from a certain person or place. If the conditions of the peace bond are met successfully, the charges against the accused may be withdrawn. Restitution is also referred to as compensation. This sentence requires the offender to pay back the victim for the harm or loss he or she created. Restitution usually comes in the form of money. A victim may ask the court to consider imposing restitution at the time of sentencing. A judge considers the offender's ability to pay when deciding on the amount of compensation to impose on a sentence. Restitution may also include making the offender work for the victim, although this is not common. Community service orders the offender to perform specific work in the community. A judge can dictate how many hours an offender must work in the community as well as the nature of the work. The objective of community service orders is to associate the offender with people in the community who are not criminals. This is supposed to decrease the possibility of recidivism. If a non-citizen commits a criminal offense in Canada, it is possible to sentence him or her to be deported, that is, sent back to his or her country of origin. Canadian residents who commit serious crimes in other countries may well be extradited or returned to that country to stand trial. For many summary conviction offenses, an offender may be fined instead of receiving another type of sentence. Fines may also be given for indictable offenses. If offenders cannot afford to pay, they may be enrolled in a fine option program to work in the community to pay off the debt. The most serious criminal sentence an offender can receive is imprisonment. There are various types of prison sentences as well as different types of prisons used to incarcerate offenders. Local detention centers are used if a sentence is 30 days or less. Provincial prison is used if the sentence is between 30 days and 2 years. Federal prison is used for a sentence between 2 years and life in prison. Types of prison sentences include concurrent sentences, a prison sentence for 2 or more offenses to be served at the same time. consecutive sentences, a prison sentence for 2 or more offenses to be served one after the other. Intermittent sentence, a prison sentence of 90 days or less that is served on weekends or at night. The principle of totality is a rule that looks at all circumstances of a prison sentence to ensure that it is fair. A convicted offender who is considered a very serious risk to the public may be given an indeterminate sentence. This means that he or she will be in prison indefinitely. A dangerous offender displays a brutality that is abnormal, has a pattern of aggression that is unlikely to change, is indifferent to the effects of his or her behavior, possesses sexual impulses that may cause pain or injury to others. An indeterminate sentence can end if authorities decide that the offender is no longer dangerous. In 1976, Parliament abolished capital punishment, also known as the death penalty, from the Criminal Code. Prior to 1962, a person could be sentenced to death in Canada if they were found guilty of first-degree murder. After 1962, all death sentences were commuted to life imprisonment, which eventually led to the official cancellation of capital punishment in a close vote in 1976. In 2001, the Supreme Court reaffirmed Canada's rejection of the death penalty. A recent approach to criminal sentencing is restorative justice, which focuses on forgiveness and involves a community. Sentencing circles are common in Aboriginal communities. The offender, victim, and others in the community are brought together to decide on the offender's punishment. Healing circles are an opportunity for an offender and his or her victim to voice their feelings and resolve their conflict. Releasing circles are also common in Aboriginal communities and parole boards. A plan is prepared to return the offender to society. Each province has a victim compensation fund. This is public money to compensate a victim if any of the following circumstances exist. If they have lost pay, they have pain and suffering from injuries, they have medical bills and prescriptions, a loss of income by dependents if the victim dies, for example, funeral expenses, and child support for the offspring of sexual assault. Both the Crown and the convicted offender have the right to appeal a conviction or sentence. An appeal asks the court to review and reconsider the conviction and/or the sentence that has been imposed. The party who requests the appeal is the appellant, and the party who opposes the appeal is the respondent. Prison inmates are usually eligible for parole after they have served 1/3 of their sentence, or 8 years, whichever comes first. A parole board reviews the offender's behavior in prison and decides whether or not to grant parole, that is, early release from prison. A parolee must report to a supervising officer and follow certain conditions until his or her sentence is complete. If a parolee violates any condition, they can be returned to prison. Full parole is not usually granted to offenders convicted of first-degree murder before 25 years. The federal government has the power to grant a royal prerogative of mercy, which means they can revoke a prison sentence or issue a pardon. A pardon is granted when an offender is officially excused from a crime. Parole boards review cases and advise the Solicitor General's office regarding pardons, which are often granted if a person appears to have been wrongly convicted. Having a criminal record may create many difficulties for a convicted offender, in addition to embarrassment and humiliation. A criminal record may hinder or restrict job opportunities as well as the ability to travel. Many jobs involve bonding, which guarantees the honesty of a person who handles money and other valuables. A person with a criminal record usually cannot be bonded. A convicted offender may apply for a pardon, usually 3 to 5 years after completing his or her sentence.